Well, today I have a very special guest with me. It's my colleague for many years, Susan Curcio. Susan Curcio is a professor at Montclair State University. She is in the Center for Child Advocacy. She also is an attorney and child advocate where she has a private practice in Hamilton, New Jersey. She has worked as a law guardian, and she also represents children who are accused of delinquency. That is, they have engaged in behavior that would be considered criminal if they were adults. And I'd be remiss if I didn't tell you about her former life. In her former life, she was a chief assistant prosecutor in Atlantic County, where she was the chief in charge of the Crimes Against Children unit within the Atlantic County Prosecutor's Office. How you doing, Sue?
I'm good, Joe. How are you?
I'm good. Today we'd like to talk about juvenile waiver, and before we get into the details of the New Jersey statute and the recent reform, I just want to share with the students the case of Kent versus the United States. We just looked at that in one of my classes on campus, and as you know, back in the 1960s, in fact in 1961, a young man named Morris Kent was charged with rape and robbery, and the judge and the prosecutor in that case decided that he would be better prosecuted in the adult court in the District of Columbia. Now, Morris's attorney filed a motion asking for a hearing. He wanted to be heard on the issue of whether this young man should go be tried as an adult. Well, he didn't get that hearing. In fact, the judge reported that he made a full investigation and that he was waiving jurisdiction. The investigation wasn't documented in any way, and Kent's lawyer was unable to evaluate the adequacy of that investigation. In any event, Morris Kent wound up going to the adult courts, where he was found guilty after a trial on 6 counts of housebreaking and robbery, and he wound up getting 30 to 90 years in prison. Well, the case wound its way through the appellate courts, and the United States Supreme Court eventually ruled that what the judge did was not okay, that Morris Kent was entitled to a full hearing that measured up to what they called the essentials of due process and fair treatment. And perhaps equally important, that the young man's lawyer should have had access to all the discovery, all the records that were involved in the waiver decision, and lastly, that the judge should have provided a written statement of his reasons for waiving the young man over to the adult court for prosecution. Now, that's the history behind the due process aspects of waiver in the United States. We have a waiver statute in New Jersey, do we not?
We do.
And that waiver statute was recently changed. I want you to talk a little bit about what it used to say and what it says now, and why it was changed, as some have characterized it as reformed. Tell us about the waiver statute in New Jersey.
Well, in the waiver statute in New Jersey was initially enacted in 1982, and it was amended in 1999. So as of 1982, it was possible for a child who was over the age of 14 to be waived up to the adult court. But the judge had some authority. There was discretionary waiver, there was presumptive waiver, and the judge had authority to make decisions on when a child would or would not be waived. And one of the key aspects of it was that the child had the opportunity to show that he or she had the ability to be rehabilitated within the juvenile process before he turned 19. If he could show that, the judge might withhold waiver. What happened was that there was a wave of juvenile crime, and people around the nation, not just in New Jersey, but people began to be concerned that juvenile offenders just weren't getting enough serious consequence. And New Jersey was part of that. So in 1999, New Jersey created the waiver statute that was in effect from then until our most recent change. And that waiver statute said children between 14 and 16 may be able to have an opportunity to show the judge that they can be rehabilitated before they turn 19 in the juvenile system. But that's not true for children over 16. That law said that if the child was 16 or over, and if there was probable cause to believe that the child had committed one of the enumerated offenses, and those offenses mostly involved violent crimes and crimes against persons, then all the prosecutor had to do was file its application to the court and prove the child was of requisite age, there was probable cause that the offense was committed by the child, and that child was waived. The judge did not have power for those children 16 and over to thwart the prosecutor's efforts to treat the child as an adult. For the 14 to 16-year-olds, the judge still had some power, but with regard to the 16-year-olds and up, it was called prosecutorial waiver by some.
Let me stop you there for a minute before we go on to the reformed statute, the most recent statute, which, by the way, was effective this past March, right? March 2016, the changes were effective?
Correct, March 1st. It was signed in August of 2015, and one of the interesting issues between August and March was whether the statute could be applied retroactively. As it turns out, the legislature made it effective March 1st of 2016, but the courts actually allowed it to be retroactive. So that means that between August and March of 2016, if a child came in on a waivable offense, the new law actually did apply.
I see. And that's always an issue when laws are reformed or changed, whether it applies retroactively. There's certainly constitutional dimensions to that process, but in some cases it's not that clear, and the court has ruled on that. So children who were charged with a target offense after it was signed but before it was effective may be handled under the new statute. It's retroactive in its application.
Yeah, and just to show you an example of that, if you were charged in September of 2015 and you were 14 years old but charged with murder, the prosecutor might have filed a waiver application under the old law. But since the new law had been signed, and since it eliminated the possibility of a 14-year-old being waived, the courts said, we're going to apply it retroactively. If you're 14, you committed an offense in September of 2015, you're not getting waived. You can't be waived. Case that says the state in the interest of JF.
So what happened was this retroactivity as applied in the example you just provided turned out to be to the benefit of some children who were considered waivable. If they were 14, the court was acting in a way that could be characterized as benevolently because that child may have been waived under the old statute. They could not be waived under the new statute, so they gave the 14-year-olds the benefit of the new statute. But there are other issues surrounding the Reformation and the change in the statute that might have made it deleterious to the interests of a juvenile. And we'll talk about that in a moment when we get into what the new statute looks like. Okay?
Okay, sounds good.
So before we do that, though, I want to talk about the old statute and just recap it. And correct me if I don't characterize it properly. But what you were saying was under the old statute, there were two ways that juveniles were treated based upon their age. If they were between 14 and 16, the prosecutor had a greater burden. She had to do two things, correct. The prosecutor. She had to show first that there was probable cause, that the child probably committed the murder or the armed robbery, and that despite that probable cause, that the services available to the court were such that that child could not be rehabilitated by the time they were 19. On the other hand, the lawyers that represented the children would argue that they could be rehabilitated by the time they're 19. So a kid between 14 and 16 had a shot to argue that I don't belong in the adult court, even though I may have done the crime. Fair enough?
Yes.
Now, 16 to 18, which is the balance of a child's juvenile status, all the prosecutor had to show was the child probably committed the crime, and in large part, he or she would be waived over to the adult court. Correct?
Correct.
Now, what happened? How did that change? What's the new law say about age, about whether children have a shot at showing that they can be rehabilitated by the time they are 19 using the services of the court? How has the law changed today?
Okay, well, there were a myriad of reasons that reformers said it's necessary to change the waiver law, and I won't get into those reasons right now. Instead, I will answer your question about what the changes are in the new law. There are four in particular that are important for the students to remember. First of all, the eligible waiver age was moved from 14 to 15. So no 14-year-olds, nobody under 15, could be the subject of a waiver. That's the first most important provision. The second provision is the prosecutor now has an obligation to write a written rationale for waiver provided to the court, but this written rationale has to include the prosecutor's evaluation or assessment or balancing of certain factors that the prosecutor took into consideration before he decided to make a waiver application on the child. And those factors include not only the nature and circumstances of the crime or the crime that has been charged and the age of the child, but they include the child's child welfare history, whether or not the child is classified educationally, and what the impact of that classification might be on the child. The factors also include any mental health concerns or substance abuse issues that the child may have. So under this new law, the prosecutor has an affirmative obligation to balance in characteristics and factors that are individual to the child, that relate to this particular child, and to explain with particularized individuality how the prosecutor balanced the factors in favor of waiver of this particular child.
They have to go to the judge, those factors, and they have to be documented and written by the prosecutor. Now,
correct.
Among those factors are, as you point out, social, behavioral, psychological, and other individual dynamics that the prosecutor has to address. They simply can't just say we have probable cause. They have to justify that in light of that probable cause, there are factors which demonstrate the child should be waived rather than kept in the juvenile court, and those factors outweigh any of these mitigating factors.
Yes, they're not called aggravating and mitigating, but that terminology is probably accurate. And some of the things that are factors the prosecutor has to consider are factors that may be provided by the defense or the court. It's not something the prosecutor has to go ferret out himself. So the defense, for instance, may have a school classification of a child as emotionally disturbed, and may give that to the prosecutor and say, before you waive this child, go ahead and look at this educational classification and see how that weighs in. And in order to accommodate the prosecutor's ability to look at these factors, one of the things the statute did, which you may consider important for your students as well, is it moved the filing date so that used to be the prosecutor had 30 days to file an application for waiver, but now, where the prosecutor has all these factors to evaluate, the prosecutor has 60 days to file.
That permits both sides to provide more information to the court, do a more diligent investigation, and hopefully inures to the benefit of the child, because more information, more individual dynamics, a better sense of who this person is and whether this is appropriate or not, one would hope would lead to better outcomes. Now, if that's the case, there is a change then in 2016, and that is, in the past, the prosecutor did not have to file this statement of reasons. Is that a change?
The prosecutor had a due process requirement to provide notice as to what his or her position was with regard to the probable cause and the reasons for waiver. So the prosecutor was still filing that. It was not a rationale that has the detail that's required now, and it did not involve its affirmative requirement that the prosecutor consider these factors that are now statutory. And the third thing is important too, Joe. The third change is that now, when the court gets this application of the prosecutor, the court can deny the prosecutor's motion if the court is clearly convinced that the prosecutor abused his discretion in the weighing of those factors. So the judge now is not just looking at whether there's probable cause for the child to be waived up. Now the prosecutor is looking at whether there's probable cause. That's, of course, a pivotal issue. And then secondly, the judge is looking at whether the prosecutor adequately and fairly balanced these factors that the prosecutor had to look at.
So there's greater judicial oversight. Well, Sue, you said there were 4 meaningful changes in the waiver law, and you described them. You talked about the age, you talked about the weighing of factors by the prosecutor and the individual dynamics that need to be considered. You also mentioned judicial oversight, that the prosecutor has to be fair, and if there's evidence that they're arbitrary or unfair, the judge has the right to overrule the prosecutor. What's the last aspect of the waiver statute that was a meaningful change?
Well, Joe, some people call this last provision a waiver batch, and others call it a reversion clause. What it provides is that if a youth is waived into the adult court or transferred into the adult court, and then the youth is not convicted of a waivable offense, but of some other lesser offense, then that conviction is going to be sent back into the juvenile court for sentencing for disposition. The reason for this change in the new law is that one of the things that was happening under the old waiver statute is that children would be waived into the adult court on all the charges that were pending against them. And usually the way it works is that the prosecutor charges on the basis of probable cause, and that means that there's a reason to believe that a charge can be convicted. So the prosecutor will charge at the outer limit, all the charges, the highest level of charges. That once the child gets into the adult court, a jury may hear the evidence and decide, well, there's proof beyond a reasonable doubt of a lesser charge, but not of the waiver charge. And so they may convict him of the lesser and not the greater. An example would be this. Let's assume that a youth is, say, 15 years old, and he is stopped by the police walking down the street carrying a gun that is loaded, and he does not have a permit for that gun. So he's charged, a permit to carry, that is. So he's charged with possession of a handgun without a permit. That is not a waivable offense. But assume also that the police conduct an investigation, and they find out that the day before the arrest of the youth, he had been in a fight with some other youth who threatened him. So the police have reason to believe, and the prosecutor has reason to believe, that when the youth was walking down the street the day of the arrest, his purpose in carrying the gun was to use it unlawfully against the kid who had threatened him the day before. So that is a waiver-eligible offense, possession of a weapon to use unlawfully against the person of another. So let's assume that the youth gets waived into the adult court. It goes to trial before a jury, and the jury says, well, there's proof beyond a reasonable doubt that he possessed a gun without a permit. He had a gun. He had no permit. But there's no stated purpose. There's no attempt to use the gun. We don't find proof beyond a reasonable doubt that his purpose in carrying that gun was to use it aggressively or assertively or unlawfully against this person who threatened it. So we're going to acquit him on that one. Well, if that were to happen, the youth's conviction for possession of the handgun without a permit will be referred back, or it will revert back to the juvenile delinquency court. It will be a juvenile conviction, and it will be handled for sentencing and disposition as a juvenile conviction. The waiver will become irrelevant. So that's the meaning of the waiver back clause, and that is the fourth important change in the waiver statute.
As you indicated when you began to touch upon the motivation for this statute, you suggested that there are sometimes offenses that are waivable offenses that there is probable cause for, but there's not sufficient evidence to prove beyond a reasonable doubt. Nevertheless, the prosecutor would move that matter and it would wind up in the adult court, and that youth might have the charges dismissed either by the jury or by the prosecutor who is resolving the case via plea bargain. Now with the reversion clause, child goes back to the juvenile division and they don't suffer all of the severe consequences they might have incurred had they been convicted in the adult court, which includes a felony conviction, which includes public scrutiny and even media coverage and other more enduring disabilities.
That's right.
So those are the four new aspects of the waiver law. There's one last one that perhaps is significant to the children who were disciplined in this manner, but is not likely to have occurred too often. That is solitary confinement. Among the options in the correctional facilities was to place children in solitary confinement. That's not an option anymore under the new waiver statute. Is that right?
That is right. Sometimes in the past, children in New Jersey and around the nation were managed in the institutions by being placed in solitary confinement. Their behavior may have been such that The authorities within the correctional facility believed that they shouldn't be in the general population, and the children would be maintained in solitary confinement. There's been research completed in the 21st century that suggests that solitary confinement does not have positive effect, does not have good outcomes for children, and it's generally not fair. So solitary confinement has been eliminated as an optional under this new law, and people who are running institutions, whether they be, that involve the incarceration of children under 18, are not permitted now to hold them in solitary confinement.
Well, you mentioned this research. That is part of an overall body of research that addresses the issue of the development of the adolescent brain and its impact on risk aversion and its impact on decision making, among other things. Perhaps in a future podcast we can address that. And there's another issue that's related to waiver, and that is the issue of disproportionality. The statistics show that there is a disparate impact among children of color, especially African American children, not only in New Jersey but around the country, involving waiver and generally commitment and disposition within the juvenile justice system. Perhaps we can talk about that in a future podcast.
I would look forward to doing that, Joe.
Well, thank you for your time and expertise, Sue. It was a pleasure talking to you, and we'll talk again when we address those other important issues.
Thanks, Joe. Thanks for having me.
All right. Take care.